If you are one of the thousands of individuals considering obtaining either lawsuit funding or settlement loans, how do you know whether you should retain an attorney? More importantly, once you've decided to retain an attorney, what are the keys to selecting the most appropriate attorney in your case? Unfortunately, this is a situation in which many plaintiffs find themselves. Furthermore, it is a very common occurrence that this is performed in some lackadaisical fashion. However, failure to select a competent attorney, an attorney who is both capable of providing and willing to provide reliable counsel in such situations, may result in a disastrous outcome in your case. There's little doubt that those individuals seeking pre-settlement loans often find themselves dealing with myriad factors over which they have little to no control. However, they are in complete control of making certain that the attorney from whom they seek counsel is one who is well suited to provide the services that they actually need to obtain a favorable outcome in the underlying lawsuit. Of course, this presupposes that the claim being brought forward has merit. Make no mistake about it, even the best of cases often fall short. Once cases get to the courthouse, many factors play a significant role in the outcome of your case. The judge who presides over your case can make or break a case. This is often determined by the jurisdiction in which a case must be filed. Oftentimes attorneys have little choice over the judge who will be presiding over a particular case. Furthermore, the jury pool from which jurors will be selected will also be a determining factor. It is an unfortunate fact of life that individuals of certain ethnic groups are going to suffer a much less favorable fate in some geographical regions than others. Although we can pretend this situation doesn't occur in today's enlightened society, we fool ourselves if we believe that that is so. Individuals who seek to obtain lawsuit loans must keep in mind that their integrity will be assessed from the very beginning of the claim. In many instances, the payers are going to be viewing the plaintiff's actions with suspicion, irrespective of the plaintiff's best efforts. Plaintiffs who are prone to make outlandish demands, express unrealistic settlement proposals, present cases that suggest injuries are exaggerated, etc., are likely to find rough sledding in pursuing lawsuit funding and settlement loans. The first step in identifying an attorney who is appropriate for your case is to identify an attorney who is willing to listen to what it is that you wish to present. Attorneys who don't have time for their clients are not sufficiently competent to represent them in an underlying case. In fact, no attorney should take on a client if that attorney does not feel as though they can devote sufficient time to represent that client in a zealous manner. Unfortunately, many personal injury attorneys today conduct practices known as mills. This is an unfortunate circumstance and the bane on the legal profession. Most attorneys are competent and more than willing to assist their clients in a zealous fashion. These attorneys will do everything within their power, that is, that may be done in both a professional and ethical manner, to assist their clients in gaining a favorable outcome both in the underlying lawsuit and obtaining the lawsuit funding and settlement loans they seek. The vast majority of attorneys plaintiffs will encounter attorneys with a great deal of integrity and respect for their clients. They're willing to meet with their clients, assuming reasonable notice is provided. They will answer questions forthrightly. They will do whatever they can to make certain that their clients readily understand the issues that are at stake in the case and provide those clients with a realistic potential outcome of the case. For those of you seeking lawsuit funding and settlement loans, make certain that you approach selection of your attorney with care. Failure to do so may not only result in a denial of any requested pre-settlement loans, but may also result in a disastrous outcome of the underlying lawsuit. Remember, plaintiffs for whom the underlying lawsuit is unlikely to prevail are unlikely to obtain the lawsuit loans they seek.